This March 18th regular meeting of the Jackson County Library District Board is now called to order. Can we have a roll call, please?
Susan Kiefer.
Present.
Patty Jensen.
Here.
Kevin Keating.
Present.
Marta Teranzi.
I don't think she'll be with us, but she might join later.
Marissa Shepard.
Present.
All right. Land acknowledgements. Jackson County Library Services acknowledges that its libraries are located within the traditional lands of the Shasta, Takelma, and Lagawa people, whose descendants are now identified as members of the Confederated Tribes of Siletz Indians and Confederated Tribes of Grand Ronde, as well as of the Cow Creek Band of Umpqua Tribe of Indians and the Modoc Nation, who were forced to relocate to Oklahoma. We take this moment to recognize the indigenous peoples whose traditional lands are where residents of Jackson County live today. JCLS is committed to fostering understanding, deep respect, and honor for indigenous people, and we encourage you to learn more about the land you reside on. For more information, go to jcls.org/land. And we are going to check on maybe should I introduce Frank now? Oh wait.
This is the introduction section.
Yeah, maybe I should take this moment to introduce Frank. Why don't you come up and I'll introduce you. This is Frank Phillips. He will be signing a contract to be our interim director later today, I believe. And I just thought, since this is the introductions part of the meeting, I should identify him for you all.
Thanks very much.
Thank you. Does anyone else have amendments for the agenda? We're going to move Mark Wolf's presentation, which is under reports, up to immediately following the consent agenda so he can make his presentation and not sit through our whole board meeting. But does anyone else have any other agenda amendments? Okay, if not, we will proceed with the agenda.
Nobody's going to speak. Nobody's going to speak in the audience.
No, there was one person signed up, but she didn't really want to speak.
Okay.
So can I have a motion to approve the consent agenda? Does anyone want anything moved off the consent agenda?
First, you have the motion.
Okay.
Oh,
I move to approve the consent agenda.
I second.
All right.
Yep.
All right. Now, does anyone have anything they want to take off the consent agenda? All right. Any discussion? All in favor, please signify by saying aye. Aye.
Okay.
Opposed? Motion carries. All right. And Mark Wolf is on the screen, so he's in our waiting room. Mark Wolf is a labor lawyer, and he's going to talk to us about the process of getting the union up and running and a contract negotiated and all that good stuff that I know nothing about.
Yes, I am here. My video, when I click on the video, it says it is disabled by the host. So I don't know if we can fix that. And really more importantly, it'd be nice for you all to be able to see my screen. I've got a few slides that would be helpful.
Where the host is working on making you visible.
Okay, thank you.
Oh, there he is.
There we are. Excellent.
Thank you, Yoli.
All right, so let's do. Okay, and are you all able to see my screen and see this first slide, PECPA 101?
We are.
Yes.
Okay, great. So my name is Mark Wolf. I'm a labor attorney, work here out of Eugene. Been doing this about 10 years. I'm with the local government law group. And yeah, as you mentioned there, your staff have recently organized, and part of that process now is to negotiate a collective bargaining agreement. And that's kind of the world that I live in. And so I'm here to provide a little bit of overview of what that process is, um, introduce you to some terminology that you might be hearing, give you some timelines that you might expect, and then a few points on kind of what bargaining looks like and kind of how to stay out of trouble. So with that, I'm just going to keep pressing through. If there are questions, I can't really see arms raised very well, but if somebody wants to interject and stop me, feel free. So PECPA 101. So what is PECPA? So PECPA is the Public Employees Collective Bargaining Act. So this is a set of statutes that governs the framework for labor management relationships. Specifically, kind of today, it outlines what collective bargaining is, what are the parties' obligations, what are the timelines, and what are things that you are obligated to bargain over. And I think that this provides some insight into kind of what these statutes provide, and we're certainly not going into great detail into the statutes, but the purpose of the PECPA is kind of threefold. One is to obligate public employers, public employees, and their representatives to enter into collective negotiations on employment relations, and then to enter into written and signed contracts evidencing those agreements. And then lastly is to promote the improvement of the employer-employee relations by recognizing the right of the employees to join and be represented by organizations in their employment. So that's the purpose. The purpose is, I kind of think of it is to get a group of employees kind of on the same playing field, so to speak, as the public employer, and to negotiate or to bargain over employment relations. And we'll get into what that is. It's hours, it's working conditions, it's vacations, it's sick leave, it's those types of things. So bargaining timelines. So I like to start here, and these are to some extent the minimums. So the PECPA, the statutes say that the parties, the labor group and the public employer must bargain for 150 days or more as part of this process. Now, that's with the big caveat that, of course, the parties could reach an agreement on day one. There's no prohibition on that. You don't have to go 150 days, but 150 days is the mark before either side can move to the next process in the statutes. The next process is mediation. So if the parties can't come up with the CBA, an agreement on their own, then the next step is to bring in a mediator. And the Oregon Employment Relations Board is the state agency that oversees and enforces the PECPA, and they have 3 state mediators, and so they'll send one down and try to work with the parties to bring the parties closer together and hopefully reach an agreement. And that's 15 days or more. So that's really 1 or 2 mediation sessions. It can be more. The next step in the process is a declaration of impasse, which means that look, we've done our 150 days of bargaining, we've been through mediation, we still can't reach an agreement, and that triggers some obligations for each side to submit a final offer and then to cost out what that final offer costs. And then there's a 30-day cooling off period. And then this is where things can deviate depending on what type of labor group that we're talking about. So library folks and nurses and teachers and public works departments, those folks, if they're in a union and no deal is reached, would have the remedy or the ability to go on strike to try to put some pressure on a public employer to get the terms and conditions that they like. So you might see teachers on strike, you'll see nurses on strike, but you don't see police officers on strike and you don't see firefighters on strike. Those groups are specifically prohibited within these statutes from going on strike. So that's a little deviation that we don't really need to worry about here. But this is just generally the timeline and the structure of what collective bargaining looks like. Now, of course, we're nowhere near the final offers or strikes or anything, and the 150 days will get started here in the near future. So, what is collective bargaining? So we talked about some of these timelines that you have some obligations over, but what is it that we have to do during bargaining? And the statutes give us insight into what your obligations are. And so it's a mutual obligation to meet and confer in good faith regarding employment relations for the purpose of negotiations over mandatory subjects. So it's a mutual obligation on the public employer and the public employees to meet and confer in good faith. We'll get into what that means regarding employment relations for the purposes of negotiations over mandatory subjects. Wow. So what does that mean? So employment relations, these are generally the categories of things that folks are obligated to negotiate over. So anything concerning direct or indirect monetary benefits. So that's easy. So wages and overtime and certification pay and longevity pay and all that stuff. Hours of work, vacations, the vacation accrual rates and usage and caps, and same with sick leave and grievance procedures. And then this last one, other conditions of employment. So that doesn't give us a whole lot of insight. That's kind of a catch-all that we're not going to get into today. But generally speaking, employment relations and the things that you need to bargain over are money things, hours, vacations, sick leave, grievance procedures. Those are all specified in the statute. So it doesn't quite end there, and we're not getting into the details by any means of what a mandatory subject is, but stuff could fall in the direct or indirect monetary benefit category. For example, your rate of pay. So that's clearly an employment relation. But if there was a proposal, for example, and this would never happen, just a hypothetical, if there was a proposal to pay somebody less than minimum wage, that would be a prohibited subject that would not need to be discussed. So while it is tied to money and it's an employment relation, falls in that category, it would be a prohibited subject of bargaining. Again, we're not getting into that, but I just raise that as what we're talking about in bargaining are mandatory subjects of bargaining, and those are the things that public employers and employee groups are obligated to negotiate over. So what does bargaining really look like? Well, the employer will form a negotiations team, and the labor group will form their team. Each team will elicit feedback. So in this case, the district's team will talk to the board and can do so in private in executive sessions, of course, so that you're not showing your cards in a negotiation. And each negotiation team elicits feedback and tries to figure out what's important, tries to figure out what you can afford. And then the negotiation teams meet at mutually agreed dates, times, and locations and exchange proposals and counter proposals and elicit feedback and try to find justifications and try to kind of work out the deal at the bargaining table. Notably, concessions are not required. The PECBA, these statutes, they don't require either side to make any concessions. All they require is that you meet and confer in good faith. And the goal, each side's negotiating team, the goal is to reach tentative agreements, which are agreements between the negotiating team that will then be brought to the entire the voting body. So the labor group will have its voting mechanisms, and of course, you, the board, would vote ultimately on a fully TA'd collective bargaining agreement. So the board's role, I mean, generally speaking, this is just a generality, is that a board or a council or a county commission is generally a policy making body and more interested in the big picture items. How much are you paying your folks? What kind of health insurance premiums are you helping with? How much paid time off are you providing? Generally speaking, a board is not too concerned about the process for timing of submitting a request for vacation and the process for that. So again, the board can meet in executive sessions to talk with the negotiating team, to review union proposals, to review proposals that you might want to put out there, and so. I guess be prepared that there will be some executive sessions revolving around those topics. And then, of course, the goal is that both sides reach a tentative agreement that is sure to be, ratified by their voting membership and by the board. So bargaining considerations, what are some things that, that maybe we ought to be thinking about now is what's the total cost of compensation, and can you pay for it? It's, wages, of course, have financial impacts in other areas. Compensation comparison. Do we know how we, sit in the market? During bargaining, potentially focus on addressing some non-economic proposals first. Both sides are going to want to identify core issues. If there's a change to the status quo, why is that? And the status quo is kind of a term in the labor world that, to some extent, there's a presumption that things should stay the same, and if one side's looking to change the way things have been done, maybe there needs to be some justification for that. And then avoid regressive bargaining. So this is another thing that I always like to touch on, is that the statutes are clear that, and this applies to both employees and employers, is that you essentially can't make a worse proposal than you've previously made. And maybe that's not a great way of saying it, but for example, if a public employer proposed, let's say, a 3% wage increase, and that was rejected. Well, that public employer cannot say, the heck with that. If they don't want 3, let's give them 2.5. You can't do that. That would be regressive bargaining. And so we want to avoid that. And so that leads to unfair labor practices, or ULPs. And these are the things that we want to avoid. So the duty to bargain in good faith is maybe the most relevant here. And again, that was in the definition of collective bargaining, is to meet and confer in good faith. And so we touched on regressive bargaining. We want to avoid that. There's a duty to provide information. And so under the PECBA, there's a different standard for a employee group to get information that is different than a Oregon public records request, where anybody off the street can come in and make a request for public records, and there's various exemptions, and there's timelines, and there's maybe some fees. That is a separate and distinct process for providing information when we're in the world of PECBA. Direct dealing, we want to avoid direct dealing. So again, the statutes and the PECPA is designed that a labor group will have their negotiation team, and the employer will have their negotiation team, and those are the folks that ought to be negotiating, and avoid going around those negotiation teams to try to reach some sort of side deal that could lead to a direct dealing claim. A per se violation of the duty to bargain in good faith is a unilateral change to a mandatory subject of bargaining. So you can't just go out and make changes to a mandatory subject of bargaining without first negotiating that with the labor group. And then there's surface bargaining or totality of conduct. So the duty to bargain in good faith obligates both sides to put some thought, put some effort, put some consideration into proposals, right? You can't just show up, receive a bunch of proposals and say, we're not interested. We're not even going to read them. Like, that would be surface bargaining. A couple other ULPs, and I'm going to slide through these relatively quick, but there are public employees have rights under the PECPA to engage in union protected activity. And so public employers cannot take action because of or in the interference of those rights. And so it's just something to be cognizant of. Similarly, it is an unfair labor practice to encourage or discourage union membership. So you want to avoid that. And avoid employer domination or interference with or assistance to labor organizations. And so the remedies for a ULP, the Oregon Employment Relations Board, or the ERB, can order a cease and desist, make you post it at your work site. Not a fun thing to go through. They can order affirmative relief to some extent right any wrongs. They can award costs to the prevailing party, attorney's fees, and in some instances a civil penalty, so some monetary fines. Another reason to avoid these. So how to avoid them? For a board or a council or whatever is just refrain from discussing the stuff we're going to be bargaining over outside of the executive session. Again, you'll have opportunities to talk with the district's negotiating team. And this prevents direct dealing claims, it prevents interference claims, and it helps keep the board out of trouble.
Mm-hmm.
Any questions? And I think I stayed pretty close to my 20-minute allotment.
That was extremely helpful. Thank you, Mark.
Yeah, you bet.
Put your mic on.
Can we get a copy of that presentation sent to the board?
I'd be happy to.
Great. That would be great.
Awesome.
It would be great to have that to refer to after. Hi, Marta. Do you have is that a hand up or just applause?
I
I
think
think it
she's
was
happy.
applause.
Just applause.
All right. Is there ever, one question that people have been batting around on this board for a while, is there ever a member of the board on the negotiating team?
Yeah, so good question. So I can't see you all anymore. Not that maybe matters, but there's no prohibition on that. I suppose there might be a prohibition of having a quorum sitting on the negotiating team, because that would just cause all sorts of public meeting nightmares. So a member of the board can be on the negotiating team, but part of the consideration for that is there can be a lot of meetings during business hours, and so somebody's got to be prepared to commit to what could be a long process. Sometimes the employees will look to you, the board member, as, why aren't you giving us the money that we're asking for? You or the board have that authority. So it can kind of put you in an awkward spot. And another thing to consider is once a CBA has been tentatively agreed to, the negotiating team has an obligation to advocate to its members or to the board to pass that. So if a board member's on that negotiating team, they kind of have to already vote yes if an agreement was reached. So it's just another.
How
layer of
are the
complexity.
negotiating teams chosen?
So from an I mean, I can talk to an employer side. Is generally you kind of want somebody in HR, and you kind of generally want somebody with some ability to run some financials. You want some folks that know kind of the operations and how the business operates. So there's really no one size fits all.
Kevin,
So would you as legal representative, or do we have other legal representation on the negotiating committee? I mean, let's presume that maybe we're not the best at negotiating labor contracts. Can we hire someone to do that for us?
Yeah, and I think I'm going to be helping out at least at the start and working with your staff to figure out if I should remain or not.
other questions? Well, I don't see any hands up. Oh, Kevin has one more. Go.
Let's say I wanted to attend the negotiations without being a part of the negotiation team and not triggering the obligation to advocate. Is that possible?
Good question. So potentially, and that might be something that is addressed in some ground rules as a part of the negotiation. Typically, each team will kind of set some ground rules if maybe they want some members to also be able to attend. So it's possible, and I might have a more firm answer for you, next week.
Okay. So I have a question. Okay, one more.
Yes. When will this process all begin officially? Or maybe it has.
Yeah.
Well, so the 150-day timeline has not commenced, but I believe that's going to start next week.
So what are the steps to get to the 150 days of negotiation? What are we doing now? What's happening now?
So there's going to be a meeting, and at this first meeting, typically the labor group comes with proposals first, and once either side has sent proposals to the other side, that triggers the 150-day clock to start. So this first meeting might not happen, right? I mean, it might just be, hey, we're a new group. Let's work on finding kind of how we're going to do this process and find dates and times that we're going to work through this. And it very well might end up being that proposals are sent and the clock would start.
So our employees have decided to have SEIU, I believe, represent them.
Mm-hmm.
So I assume a group of employees and a group from SEIU is currently working on getting things set up so that we get to the 150-day proposal beginning.
I think that's a fair assumption, and I think we'll know more next week. But yeah, that's generally what would happen is SEIU or AFSCME or Teamsters or whoever the labor group is would have one or two of their folks work with 3 to 4 to 8. I mean, I don't know how many are going to be a part of this group, but yeah, and then they try to elicit feedback from their members in various methods to try to figure out what it is that's important to them.
How big are the negotiating teams generally? What's sort of an optimum size for a negotiating team?
Good question. Anywhere from maybe 3 or 4 on each team upwards. I've got one that I'm going with that it seems like we got about 8 of us on each side, and that can fill up a room, but anywhere kind of in that range.
Okay.
Is it best to have an odd number in case you need to break a tie?
No.
Okay.
Because I don't think that so like an employer's negotiating team we shouldn't be having to break ties internally, I suppose, and it should be more of a collective of this is the feedback that the board has provided, this is the feedback that supervisors have provided, and so this is the proposal that we want to pass. Certainly there's 5 of you all, and so if the CBA that is ultimately brought back, I mean that's where having an odd number would be helpful. Again, the goal would be that all 5 of you would vote yes.
All right. Thank you.
So we are not likely to see you again, except when we get to perhaps another stage, or?
Yeah, good question. I very well might be at an executive session with you all, and we can figure out maybe some ways to get you some information in the interim, just to keep you all up to speed on kind of what's going on and how this process is moving. And I can certainly work with staff on that.
All right. Okay. Any other questions for Mark? Thank you very much.
You bet. Thank you. Have a good rest of your meeting.
We'll talk to you again.
Okay.
All right. So first up under new business is the Hunter Communications E-rate contract. Kelda, you're on.
All right. I am so happy to be bringing this to you. So in your packets, you have an agenda item memo for our E-rate funded Hunter Communications contract. The contract, I actually just received it, reviewed from legal just before coming down here. So I don't have it in my hot hands, but I do have some of the exhibits if you're curious. Does anybody have any questions? This is our internet services. The contract is for 3 years with 2 one-year optional extensions. And it includes a switch upgrade, a big switch upgrade, and this starts in July. So this contract would take effect beginning in July.
All right. I have a motion to approve this contract, and then we can talk about it more, perhaps.
This is Marta, and I second.
Thank you. It's been moved and seconded that we approve this contract to with Hunter dealing with E-rate. Or is there any discussion? No discussion. All right. All in favor, please signify by saying aye.
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 Hi.
I know we moved past discussion, but I am understand this correctly. We're saving 117,000.
Yep, we are.
Put that in there for you to see. Yes.
$117,607.04.
We get a 90% discount.
You guys rock.
So yeah, it's a 90% discount on the category 1 items that are eligible for category 1, and then 85% discount on the equipment and other things that are eligible for category 2. So yes, it's a significant savings.
Wow.
It's a process, but so which is why I'm so relieved to be bringing it to you today. And we have to
can
file by the end of the month.
Thank you so much.
Thank
That's
you.
terrific.
I believe the motion carried. So we are now ready to go on E-rate. That's great. Next, you can just keep going with the pollinator garden.
I'm feeling good about all these. Okay. So this also in your packet, I am so excited to be bringing you the Phoenix Pollinator Garden contract for approval. So this is a project that hasn't even started, and it's been years in the making. So I'm hoping to approve moving forward with the contract with solid ground. Landscaping to implement the pollinator garden at the Phoenix branch.
Hmm.
And the intention is to bring the contract back. I mean, the contract's not part of it.
I have it figured.
Okay, so we'll,
So
We're
I was
gonna
thinking after
approve
the
this
meeting, we
contract.
can, yeah, so I have it with me.
okay. Can we have a motion to approve this contract for the pollinator garden?
I move to accept the, oh, sorry. So moved.
Patty's moving approval. We have a second? I'll second it. Is there discussion? So,
Yep. I have a
Kevin.
quick question on the process in the back on page 13.
Yeah.
Regarding the last paragraph on page 13, negotiations. So I guess I remember the old ITB on the 24th of 2025. And then we went back to January, we approved one and then rescinded it. When you say the other proposer solid ground, is that a difference from the one we proposed?
Right, so yeah, in summary, so we posted it a year ago.
Yeah.
Resulted in a non-award.
Right.
We posted it again, and the lowest bidder that we were first talking with ended up being non-responsive. So we rescinded that notice of intent to award, and then we went and were able to talk with the second bidder.
Do you know why they refused to respond? Is that what I'm hearing?
They were found non-responsive. There were a number of criteria where it was in the district's best interest not to enter into contract.
Okay.
any further discussion? All in favor, please say aye.
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 Opposed? Oh, all in favor. I think everybody's voted aye. Motion carried. And one more.
Number 3. All right, so this one is the Solar Spectrum artist, Peter Erskine, who is doing the 100 Libraries project. I've been talking about it for a long time. He came and visited last January. 13 of our branches are set to receive donated artwork, prism panels or boxes that will create rainbows in our buildings with the lovely sunlight that we have.
So the cost, well, let's get them.
Move
We have a
approval.
motion. Move approval. Would you have a second?
I second.
Patty second. Kevin move. Approval. Patty seconded. Do we? So any costs would be costs of installation?
No,
Are there any other costs?
I have that contract
all
in
right.
agreement with me to share as well with you.
Okay.
So he is donating his time, all the materials, the installation, everything, and the estimated value for all 13 pieces of, or 13 installations. Some I think might even include multiple pieces, is $150,000. And so that's what he's donating to us. However, what we have agreed to pay for is in case we need to rent a lift, get access to a lift or a ladder or something to help with the installation. So
That seems
that's what we're doing. And we estimate approximately $10,000, no more than that, certainly. And likely a lot less, but I wanted to get you something. So,
all right.
and none of that has been scheduled or arranged yet, but he's hoping, I think he's going to be ready to schedule a visit to begin installing as soon as we have this.
Great. Any further discussion?
I do have one more question on that.
Yeah.
Okay.
So if we're talking about $150,000 donation, is that something he has to put through the foundation so he gets a tax write-off on that, or is that?
I don't know. That hadn't been considered. He's worked with a number of other libraries in Oregon already, and that hadn't actually come up. I can certainly find out more.
That might be interesting to ask.
Yeah.
Thanks.
In general, people who make the donation, a donation like this would have to provide their own valuation of the donation.
Sure, I'm just making sure he gets any deductions they need.
Right.
So yeah.
All right. Any other discussion? All in favor, please say aye.
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 Motion carries. All right.
Thank you. Thank you.
Thank you.
This is excellent.
It's great getting these things all done.
Mhm.
All right. Next up is the contract. Well, the resolution 2026-6 contract emergency procurement legal counsel.
All right. So first up, real quick, I just wanted to mention that my associate Hannah has provided all of the efforts with Kelda on those prior 3 contracts while I was busy working on all of these things. So you wouldn't have been able to be quite as productive today if it weren't for her and her diligence in helping with all of those things. So
Tell
I
Hannah
didn't want
thank
to take
you.
any of the credit for that. Hannah did a wonderful job, and I really appreciate her jumping on those things.
Thank you.
Yeah.
Thank you, Hannah.
So with that said, so before you is a resolution that I have prepared. We talked briefly about this once before, but basically in order to be able to do a direct procurement of a services contract for an interim director, in this circumstance, the best option to do that is through an Oregon statute that allows you to directly procure in the event of an emergency, which we're looking at as the termination of the library director and the immediate vacancy that followed in that position. So basically, rather than having a long-standing vacancy while you went through the entire process to try and find a permanent director, this resolution outlines the requirements for like lays out the foundation for being able to find that there's an emergency need that allows the direct appointment of that contract. So that's the basis of it.
So we should get a motion on the table
A motion
to
would be wonderful.
approve this. All right.
Move to approve resolution 2026-06 to utilize emergency procurement procedure to enter into.
Would you turn your microphone on, please?
Thank you. I move to approve resolution 2026-06 to utilize emergency procurement procedures to enter into a contract for an interim director.
This is Marta, and I second.
Thank you very much. Is there discussion of this proposal to set up emergency procurement procedures as outlined? Oh, Marta.
It looks really straightforward to me. Thank you to the legal team for helping put it together. I have no concerns as presented.
All right. Any others? Can we have a vote then? All in favor, please signify. Do we need to do a roll call on
Yes,
this one?
please. Thank you.
Yoli.
Susan Kiefer,
Aye.
Kevin Keating,
Yes.
Marissa Shepherd,
Yes.
Marta Teranci,
Yes.
Patty Jensen.
Yes.
Motion carries. We can now proceed with this one. Okay. So the next thing up is the interim library director contract, which we've just made possible, I think.
That's
Legal counsel here still.
Yes. Okay, so in the packet is included a draft of a contract for the hiring of the interim director as an independent contractor. There are 3 potential changes to this contract that have come up since yesterday when this was put together. I want to go over those, but at this point, my recommendation is that I think that you could possibly make a motion to approve this with a potential change that has not yet been determined. But at the moment, I don't think that it's ready for signature, and I'll explain why. So the first change that has been made would be on it's going to be page 24 of your packet in the insurance section. Letter A is for workers' compensation insurance. We would be omitting that. There aren't going to be any employees of the independent contractor, and so there wouldn't be a need for providing. So we're just streamlining that would be omitted. The second change is for the professional liability insurance directly under that. Mr. Phillips has indicated that he would be able to have that in place within a week. And so it would just be a change to include language that says that it just has to be in place within a week of entry, the effective date of the contract. And I think that that will likely be acceptable. I don't imagine that there's going to be a whole lot of major decision making happening in the first week of the contract. I think there'll be a lot of getting up to speed. And so I believe that that is a reasonable risk, but I'm putting that out there for your consideration. The insurance wouldn't be in effect until it was in place. Anything that happened prior to that wouldn't be covered. The third change is not to any specific language. There's been a request to include an indemnification provision from Mr. Phillips. So basically that in the event that he was to be, there was a cause of action, a lawsuit or something that was brought against him and the district related to actions that he took, that the library district would agree to step in and provide protection indemnification for him. Some of those things would be covered under the insurances. So depending on what it was, general liability or professional liability. But obviously some things, traditionally if someone was an employee would be covered by the district. And as an independent contractor, there's a gap there. So this is the part that I would encourage you, I guess, not to enter into the contract until we have an answer. I have reached out to our insurance provider to make sure or get an answer to whether the district's insurance would have an issue with that provision, to what extent the district's insurance would be included. Because hypothetically, if that happened, right, the district's contingency fund is only so deep. And I think it would be prudent to at least know like whether there would be exposure to the district if something happened where you'd be having to come up with funds to pay for this, or if your insurance would provide protection for both you and the contractor in this circumstance. So I reached out this morning. We tried to get an answer by today, by the meeting. I don't have an answer for you yet. And so I would recommend that if everything else looks good with the contract, I think that you could have a motion to approve entry into the contract pending council's approval of indemnification language, assuming that it was acceptable with the contractor as well. But I would prefer that we get that information from the insurance company before you enter into the contract. It seems important.
And do you expect that to happen tomorrow?
I don't know. So the insurance is, I don't know the exact relationship, but they're connected with SDAO. And so our insurance sent it to SDAO and their attorney sent it back to me. And then I sent it back to him, saying I was the one who asked the question in the first place, and I would like SDAO's opinion and the insurance provider's opinion. And so we were waiting on hearing back from that. So it's taken a little bit of dancing to get someone who hopefully can provide the answer.
And my follow-up question is, I didn't see it in here. Is there a start date?
So the intention was that this would start effective tomorrow.
Okay.
But I would say that we need to wait until we have an answer on that and change the language. So the goal would be that we would update the effective date based on the date that we have the clarifying language. So it currently is March 19th. And the way that I structured it, knowing that you had said approximately 4 to 8 months is what you're hoping for, is that I went ahead and set the term at an 8-month term. But when you look at the termination provisions, there's options either for mutual termination or the district can unilaterally terminate if there's you hire a permanent executive director, which has not been raised as an issue from the contractor. I think the understanding generally is that this is intended to be in place until you hire a permanent. Obviously, there'd be the option to extend or amend the contract if you needed to go longer than the 8 months, but I kind of just set it as that as kind of the maximum. Same too with the financial impact and the maximum sum. I looked at, $10,000 a month for 8 months, and then a little cushion there for any potential expenses, because the contract would also include coverage of like direct expenditures if there was like a training or a conference or something that you wanted them to attend, that would be included in their reimbursements.
So is the March 19th still doable depending on what we hear tomorrow?
We should have the motion include some flexibility on the start date.
Yeah, so the start date, I would say, should not happen until we have the indemnification
understand that.
language agreed upon.
I mean, if it happened tomorrow, we could still keep the 19th.
If it happened tomorrow and we got it signed tomorrow, then that could be the start date.
We'll just keep the
But it
start
is
date
almost
flexible.
5 o'clock and I don't have an answer. And so I don't know if it's going to happen tomorrow. So I think if you wanted to, I mean, obviously put a motion on the table if you'd like to, but if you did, I think it would be fine to have that motion be, to one, include only after approval of the indemnification by legal counsel, and two, with the start date being amended based on when that approval happens. If there was an issue where we can't get that all worked out, then I would need to bring it back to you to discuss what we do with it from there.
For full transparency, because I am known to overshare, but on March 19th, 16 years ago, I made a contract with the love of my life and it's worked really well. So I'm kind of hoping that this will be a good omen if we can do it on March 19th. Just saying.
All right, well, I won't rule you out of order, but so can we have a motion?
I so
Marta has a question.
sorry.
Marta has a question. All right.
I make the motion that the board approve the contract pending the indemnification clarification from our counsel, with the start date to be adjusted accordingly upon that clarification.
Oh, magnificent. That sounds perfect. Is that okay? Kevin, Marta moves and Kevin seconds that we approve the contract with the various provisos recommended by counsel. Is there further discussion?
I have a question.
Go ahead.
So, Jacqueline, the two of the things that you mentioned before the indemnification clarification, they're on their way. It's reasonable to expect those things to be figured out without holding up the process. Would you say there are immaterial changes to the contract?
So the only change that I don't feel confident on yet is the indemnification language, and it would not be immaterial. So that's why I would say that that's my recommendation, to not approve it until we have that hammered out for sure.
But
would
the
make a
other
difference.
two, but the other two were immaterial.
The first one, the workers' compensation, is immaterial. The professional liability, extending the option to have a week to get that insurance, it's not immaterial, because if something were to happen within that first week, then that insurance wouldn't be in place. So that I guess would be a calculated risk. Yeah.
Calculated risk on the second one, although I'm not sure the candidate would want to say that, so I'm just curious.
You mean on the indemnification language? Yes, you could. I think that's a larger risk, because if the insurance company said no, there'd be no protection there. That's a much larger exposure than a week of not having professional liability insurance in place.
Okay.
Yeah.
We'll just not let him make any big decisions this first week. Or something like that.
There you go.
Other questions, comments? Yoli, would you call the roll on this? I assume that we need a roll call vote on this as well. Do we not?
I think that would be good. Let's do it.
Susan Keeper,
Yes.
Kevin Keating,
Yes.
Marissa Shepherd,
Yes.
Marta Terenzi,
Yes.
and Patty Jensen.
Yes.
Motion carries. Thank you very much. Woohoo. All right. So, moving right along, in new business, item number 12 is resolution 2026-07 Financial Authority Legal Counsel. You are once again up.
All right. So in light of the fact that we have not entered into a contract with the interim director, this one's a bit premature. So this resolution was intended to provide Mr. Phillips with the ability to enter into transactions up to $25,000. So similar to the authority that our prior library director had, to eliminate the need for coming back to you guys every time contract needs to be signed. So in its current form, this does not work because it's supposed to be effective tomorrow, and it contemplates that he has been hired under a contract which we have not entered into. I think my recommendation would be to table this one until your next meeting.
Could we just amend the effective date to coincide with the date of signing the contract?
Yeah, effective on the date of hire.
Yes, and then if for some reason, sorry, it's my job to go down rabbit holes, but if for some reason we didn't enter into the contract, then we would need to revoke.
Undo it.
Yes.
There would be no date of hire. So
there would be no date of hire, but I would say we should, terminate we should deal with that at a future board meeting. I don't want this thing floating out there with ambiguous results on it. So I think that would be fine if you'd like to do that.
Kevin? Turn your mic on.
all right, I recommend approval of resolution 2026-07 to provide Frank Phillips with the authority to enter into purchases or contracts on behalf of the district in an amount not to exceed 25,000 effective on his hire date.
Do we have a second?
A second.
Patty seconds. Is there further discussion? Let's do a roll call on this one too.
Susan Kiefer,
Yes.
Kevin Keating,
Yes.
Marissa Shepherd,
Yes.
Marta Durante,
Yes.
and Patty Jensen.
Yes. Excuse me. Yes.
Motion carries. Awesome. All right. That concludes new business. And under report, there's no unfinished business. We've dealt with Mark Wolf. So we have the JCLS benchmark report from Jenny Hour, and there she is. Oh, that looks like a weapon. We could probably give you a bit different.
Is this easier? So hi, everybody. I don't have a benchmark report for you. That was last month, and I think
Well, that's what
it was a
Fine, but it was,
yeah, that's totally fine. A lot has been going on. I don't know if you're aware. So actually, you're sort of aware. So anyway, things are going good at the foundation. We had an event on March 3rd, Dolly Parton Imagination Library event called Building, well, I won't say what it's called because I can't remember all of a sudden. But anyway, we had our luncheon event on March 3rd at the the Rogue Valley Country Club. Thank you. And it went very well. We had nearly 200 folks join us that day. Thank you, Susan. Thank you, Patty, for being there. And we also raised $55,000 so far. We have a goal of 62,000, and donations are continuing to come in for that. So the theme of it was 200 strong, creating a generation of readers, because we understand that approximately 2,000 babies are born in Jackson County every year. And so we would like to make sure that every one of those babies receives Dolly Parton Imagination Library. And the cost of that would be $62,000 in the coming year. So that's how we came up with that goal and that number. So that went very well. And we are in the midst of Library Giving Day campaign at the foundation. It is April 1st. We have a $30,000 matching gift. So every gift that we receive between now and April 1st will be doubled up to $30,000. So we're excited about that. We're about a third of the way there. So we anticipate meeting that.
Our Well-Read Book Club is going well. We have another book club on April 11th, and that will be at Quaddy North. The book is Hitchhiker's Guide to the Galaxy. Quaddy North is giving 10% of its, let me see if I get this right, A42A Syrah during the month of April to the foundation. So we're excited about that as well. And the pollinator just got voted on. Pollinator garden just got voted on. So we'll be working with a contracted grant writer to begin process on a couple of grants we've had in the queue for a little while to support that project and some other ideas we have for that. So we're excited about all of those opportunities, and yeah, we're just motoring along. The foundation is a very, very busy place these days.
That's awesome. I have a question about your goal. So 62,000 would cover all the new babies for the coming year. Is that a goal that's but we still have what, 8,000 or some? We have a bunch that are currently enrolled, so we're still paying for them.
Right.
So I assume we have some sort of a shared goal with Rotary on this. Is that
Yes.
the way it all works?
We do partner with the Rotary on this, and we do have some funds to finish out this year. And of course, we do receive funds from the state. Half the cost of the books are covered by the state as well. So
has the governor signed that law yet?
I know I have not seen that the governor has signed it yet, but I should check on that.
Hopefully she will.
Well, yeah. It's in the budget.
All right. Any questions for Ginny? Thank you very much.
Well
sounds lovely.
Thank
Don't
you.
have an accident.
Oh, sure.
Hilda, do you want to talk to us about the library reports?
Yes. So as I'm finding is usual, there are so many fabulous things to talk about. And as you can see from this report, the few that I'm choosing to highlight, it's very difficult to narrow it down. The first that I'll mention is that the library has a new electronic resource. We now offer consumerreports.org, access to consumerreports.org. This, I think this is fabulous. This is a great resource. We had it at my former library, and the response among staff when it went live for staff was so fantastic. There were folks posting about how I just had a patron come in and I recommended it right, and so it's becoming, I just overjoyed at seeing the response, and I hope the community really enjoys it because I think it's a fabulous tool. Right. What also stood out to me is the Shady Cove had in preparation for their seed giveaway, they had a group of volunteers come in and organize all the packets and things. And I was recently in a webinar in a group talking about sustainability initiatives, and folks were saying that exactly those kinds of programs that we do here are just a casual way for people to come together and be in community and have a task to do and just feel connected to one another. And I'm so pleased and excited to see that already happening here. So I thought that was great. Another database story was at Central Point. Someone was needing help with their resume and they were struggling to get their resume up to date. And they were referred to our Peterson's guide online, which has a resume builder component, and was able to get their resume done right away. And then finally, just the fabulous data from community engagement about the read and about all the wonderful things happening in that department. Those are the things that I wanted to highlight, even though I have more on my posting. Any questions?
Questions for Kelda about the report?
Yes.
Kevin, turn your microphone on.
It's going to.
I'm just gonna.
My question is really about the social media stuff. And I see the charts on here and I don't really know how to interpret it. Is it good news? Is it bad news? Maybe you can help it out.
I think there's somebody else who can answer that question.
Why don't you come up here?
From what I know, everything is trending up, and as far as being government agency with the benchmark against other government agencies, we are higher in both engagement and everything else. Very proud of them.
Great.
For their social credit.
Yeah, I would just for next month, maybe we can just see like what a goal would be for total audience on Facebook and that kind of thing. I'd love to see some benchmarks and stuff. That's great. Thank you.
Other questions about
Can somebody
library.
please repeat the microphone what was answered?
Okay,
He said he'd get the benchmarks for us.
Great, thanks.
and that things are trending up,
Yes, things are trending up, and we'll keep the data coming.
and the team is fabulous.
Other questions, comments? Congratulations. The lovely report. We're
Good
doing
job.
all kinds of great stuff. All right, that concludes the reports. And then we have a committee report coming from the Strategic Planning Committee.
Mhm. Who's going to give that?
That
Can you
would
hear
be-
me?
Yes, we can hear you.
Gotcha. I'm driving, but it's hands-free. The Strategic Planning Committee met, I believe, last week, and we agreed on an 18-month time frame, starting on hopefully the adoption of a strategic roadmap in June, which would put this roadmap at being active, valid, and something we're following and adhering to through December of 2027. This will allow for plenty of opportunity for the new permanent director to have their input and their vision reflected in it. And I'm going to ask Marissa to share perhaps her commentary. We've been, I'm going to say, amassing and distilling. Thank you to Josh Ledzinger's work and the input from the admin team. A lot of the feedback gathered from community surveys to partner stakeholder surveys to some of the inputs gathered during the facilities master plan. And this is where I hand it over to Marissa.
Right. Marissa?
Yeah, I think Marta covered it well. I didn't jump in because the one in our board packet is actually the previous meeting, which now is a little fuzzy since we had this updated meeting, but Marta summarized it well. We kind of agreed on a few key points, kind of focusing on our foundations, the basics, communication, and then just kind of continuing really the great work that the library's been doing, continuing to connect with community partners, such as La Clinica, and again, continuing to just kind of be really present in the community. I think Josh has already been leading great efforts on that. And then just kind of really centering on the like individual identity of the library, I think is kind of where we're headed, like each community, right? Kind of taking a little bit more ownership, but yeah, that's shaping up nicely. So any questions?
I don't see any hands. That's a good report from you folks, though, and we will talk about this some more, I suppose, before we run out of the current strategic plan to see what's actually in the 18-month roadmap.
Mhm.
So that concludes the items on this meeting's agenda. I would refer you all to the list of future meetings, events, and observances at the bottom. April 15th is our next regular board meeting. We have a work session on the budget scheduled for April 1st. The OLA conference will be taking place in Portland the 22nd through the 24th of April. And April 19th through the 25th is National Library Week, so we will have a proclamation about that at our next board meeting. So unless somebody else has something more for the good of the order, I will adjourn this meeting at 5:10. Thank you all.
Thanks, everybody.
Thank you.
Good job.
Thank you.
Thank you.